Delegate Lane.
Here.
Delegate Hanshaw.
Here.
Delegate McCuskey. Delegate Ireland. Delegate Fleischauer. Delegate Azinger. Delegate Schaefer. Delegate Kessinger. Delegate Sabonia. Delegate Dean. Delegate Fluharty. Delegate Foster. Delegate Summers. Delegate Markham. Delegate Byrd. Delegate Weld. Delegate Moore. Delegate Zetezelo. Delegate Fast. Delegate Rowe. Delegate Overington.
Present.
Delegate Skinner.
Yes.
Delegate Folk. And Delegate Manchin. And Mr. Chairman. Here.
Appears we do have a quorum. The first item on our agenda is approval of the minutes from the January 25th meeting. Please take a moment and look at those. I'll ask if there are any additions or corrections to the minutes. Are there any additions or corrections to the minutes? If not, Chair recognizes the gentleman from 38th.
Thank you, Mr. Chairman. I move the committee adopt the minutes from the January 25th meeting as presented.
Vice Chairman Lane moves that we adopt the minutes of the Monday, January 25th meeting as submitted. All in favor will indicate by saying aye. Aye. Opposed, nay. Ayes appear to have it. The ayes do have it. The minutes are adopted as submitted. First item on our agenda is House Bill 4145. Council, will you explain the bill?
Yes, thank you, Mr. Chairman. Good morning. I apologize for the late substitution, but if everyone could please make sure there is a version 2 that has, I believe, my handwriting on the top. It says version 2 of a committee substitute that we will be addressing today. The proposed bill 4145 actually affects 7 different code sections. So in an effort to just try to take this one at a time, I think that's what we'll do, and we will just go in order as it was, as they are in the proposed bill. The committee substitute actually just mirrors that. So for purposes of getting started, the first section of code that is affected is 20-2-6A. The bill, the original bill, had some changes, made some changes to this. The committee substitute actually repeals the entire section, 20-2-6A. The reason for this particular proposal is that as a result of removing the language that says that a person that does not have a concealed, if you have a concealed carry permit, what actually ended up happening once that's taken out is that particular section now, as it was in the original bill, does not have an age restriction on it anymore, because before the permit, the concealed carry permit limited that to people 21 years and older. If that is removed, then there is no limit on the age anymore as it was originally introduced. So it would say that anyone, any age, could carry a concealed handgun in a manner for self-defense purposes while afield, hunting, hiking, camping, or in or on a motor vehicle. After some discussions here and with the Senate council over there, there was a determination that if this particular bill passes and you no longer need the permit itself, then you can carry both openly and you can carry it in a concealed manner. And to keep this particular section in may be more problematic because it's then just taking into account different activities, such as the hiking, hunting, and camping, which you would be able to do regardless. And to bring that special attention to that without having an age restriction on it was just, we felt that was problematic. So for that reason, the committee substitute, again, version 2, does request or has in it the repeal of this entire section, 20-2-6A. If anyone has any questions about that at this time, I'm happy, or I can just move on to the next section. Again, like I said, we have 7 different sections to cover. So I'm happy to proceed in whatever manner.
Council, just go ahead and go
Okay.
through the entire bill so we can hopefully get it done before 11 o'clock.
Okay, very good. The next section that is affected by House Bill 4145 and the committee substitute is West Virginia Code Section 61-7-3. This is the section that actually, I don't believe that the committee substitute made any changes to the bill as it was proposed. What this does is just adds in the terms under 21 years of age, or who is a prohibited person or person that's prohibited from possessing firearms. And that just provides penalties for any person that is under the age of 21 or a person that is a prohibited person who carries a concealed deadly weapon without a license or other lawful authorization. It subjects them to a fine. And again, really all the proposed bill does is clarifies that that is for people that are under the age of 21 now or for prohibited persons. Also, just with respect, I believe probably to some cleanup language, that the changes within the rest of this section are somewhat minor. They change some shall be's to is, and it also changes the prior reference to the penitentiary to the state correctional facility. It also clarifies with some shalls the duties of the prosecuting attorney to ascertain what type of charge will be made to the grand jury for any violation of this particular section. The next section that is affected by House Bill 4145 is West Virginia Code Section 61-7-4. There are some changes to this, and I'll try to go over these one by one. The committee substitute, I do not believe made any changes to the bill as it is proposed. It added one thing, but did not change anything that was proposed in this particular section. So specifically, the changes that have been made in this particular section are in the first one will be in section A2. It adds the fact that when you make your application for this particular license, you have to now state that you are a resident, a United States citizen, or a legal resident thereof, in addition to being a resident of West Virginia. If you then move to page, I believe 5 of the committee substitute, it just cleans up some languages with respect to taking out the provisions of, and then the next more major change was located, I believe, on page 6. And what it does is it requires, with respect to training, when people are obtaining training, if you decide to go this route and obtain a permit, the training now must include the actual live firing of ammunition by the applicant. And that's noted twice within that paragraph. And again, that is just to make sure that the training does have that component in it from this point forward. The next change is found on page 7 of the committee substitute, and what it does, and this is from the original bill as well, it just talks about the actual people that are conducting these training sessions. And it says that when you're providing documents to show that you have completed a course, the training course, that those documents have to now include the instructor information and proof of instructor certification, including, if it is applicable, the instructor's NRA certification number. The next change is on page 8 of version 2 of the committee substitute, and it just deals with the duplicate license cards, stating that those cards that will be issued after July 1, 2017 now must be uniform in size, appearance, and information. It also adds in the following section that The state police, now in cooperation with the West Virginia Sheriff's Bureau of Professional Standards, will prepare applications for licenses and license cards. The next change, still within this section 61-7-4, is located on page 10 of version 2 of the committee substitute. This is something that was added in the committee substitute that is not present in the original bill, and it just indicates that a person who is granted a license pursuant to this section after the effective date of this section is entitled to a tax credit equal to the amount they actually paid, but not to exceed $100, which, depending upon who this person may be, if that person so chooses to ask for the tax credit, could be up to the $100 or maybe less, as the provisional licenses don't cost as much, but it may also include training. So it provides that additional tax credit for people that do obtain a license under that particular section 61-7-4. The next section is one of the new sections that is added to West Virginia Code. It is West Virginia Code 61-7-4A. It is a new section entirely, and this is the section that deals with provisional licenses for people that are between the ages of 18 and 20. It has many different requirements. Many of them mirror the requirements that are required just to obtain a license. There are a few differences. As I indicated before, I believe that the licensing fees are different for the provisional license. They are not as much as a regular permit. If I recall correctly, I believe total they're only $40 as opposed to $100. So that is one change with respect to the provisional license, or one difference between the provisional license and the regular license that is contemplated in Section 4. I also believe that one of the other changes, or one of the other differences, indicates that, let's see here, that this license does not satisfy the requirements of 18 U.S.C. 922T3, and it requires an NICS check must be performed prior to purchase of a firearm from a federally licensed firearm dealer. This one, again, similarly to the section, or section 61-7-4, also requires for the West Virginia State Police, in conjunction with the Sheriff's Bureau of Professional Standards, to prepare the uniform applications and the license cards. This also has the provision that indicates if this application, this provisional license application for people aged 18 to 20 is denied, it provides a mechanism by which that can be appealed to the circuit court, seeking a petition for review. And also, again, as the other section talks about, destroyed, or if you need to get another duplicate license. And I think that, again, similar to the original, but this is just a new section for the provisional license. And the next code section, as we journey through, is section 61-7-6. This one has a couple of changes, and let me try to go through those just in order as well. The change in the committee substitute is on page 16 at the bottom of the page on line 2. And what it does, again, after consultation with counsel over in the Senate, because this refers back to West Virginia Code section 61-7-3, which used to include, prior to this, included the information about people that have the concealed carry permit. By removing that, and only including people that are ages 18 to 20 or prohibited persons, those are the only people that Section 61-7-3 now encompass. They don't encompass, that section used to encompass just everyone, anyone that had a concealed carry permit. It now only encompasses those two classes, ages 18 to 20 and prohibited persons. So the change that was made here in the committee substitute, again on line 2, just says that it provides that, again, there are always exceptions, and these are the exceptions to those prohibitions. But it says that these exceptions are only limited to persons between the ages of 18 and 20 because we wanted to make sure that it was clear that prohibited persons, although it seems that it would be clear that prohibited persons are not eligible to have any exceptions applied to them, it was not clear because those are the only two sections or classes of people that are addressed in 61-7-3. So that is why the term or the words between the ages of 18 to 20 were added at the bottom of page 16. One of the changes on the following page actually deals with members of the Armed Forces and Reserve and National Guard. And basically, just what it indicates is that these provisions of 61-7-3 saying that you have to have a permit, this is when you do not have to. And one of those is now it states, if any member of the United States Armed Forces, Reserve, or National Guard. So it changes the wording that was there just a little bit to make sure that it encompasses all of those, all members of the Armed Forces, Reserve, or National Guard. This also, in this particular section, one of the other changes that the original bill had that is left in the committee substitute is it allows for prosecuting attorneys and judicial officers and their staff to be exempt from paying application fees. But they still can obtain a license. So it exempts them from application fees required under this article. And again, there's a specific list as to the classes of people that this applies to. And then one of the new sections that was added, and if you were in the public hearing this morning, you may have heard the chairman mention this. This is one of the other bills or one of the other issues that's out there that is likely to also touch this particular section. So in an effort to try to blend those, this was added in, and it's the subsection C on the bottom portion of page 18. What a lot of people, it's regarding the Law Enforcement Officers Safety Act. There had been some request by prosecuting attorneys to be able to carry a concealed firearm pursuant to that particular section. It is my understanding that is also being looked at on the Senate side to make sure that how that's going to happen. So that is why that was put in there. That was at the request of prosecuting attorneys. What I believe that does is that allows them, even in states in which there may not be reciprocity, if they obtain this particular certification, that they can then carry concealed into other states, even in which we may not have reciprocity. And that is the reason for the addition of that particular section or subsection C. Then, in addition, the one, again, not to be missed is subsection D. What had happened was that was originally C, and we just moved that down to D in the committee substitute. But it reads as it did in the original bill, that any person 21 years of age or older may carry a concealed deadly weapon without permit in this state, provided that the following conditions are met. This again states that you must be a United States citizen or a legal resident thereof and not a prohibited person. Then one additional thing that was added in the committee substitute is subsection E. And if you will take a moment to look at that, what that provides is that a person who displays either a valid photo identification or a concealed weapon permit, if that person is a concealed weapon permit holder, may not be unreasonably detained for purposes of verifying whether that person is a prohibited person. That is an attempt to try to be a safeguard to those people that have either a valid photo ID or a concealed carry permit if they are stopped and come into contact with law enforcement officers. The next section that we have is West Virginia Code 61-7-11A. This deals with possessing deadly weapons on educational facilities, also school buses. I believe the original bill made a minor change to that, and that was just to change the wording from, let me see here, the Division of Public Safety to State Police, so I believe that was a minor change. The committee substitute also, in hearkening back to what the chairman talked about at the public hearing into trying to incorporate and blend other bills that are out there, does also try to blend in another bill that has been introduced in the House, and it deals with public schools. And really what it says, and I think you can find that information on page 20 of the committee substitute, that is the section that says it's unlawful for a person to possess a firearm or other deadly weapon on a school bus or on a public. We have marked out private in the proposed committee substitute. These are in primary or secondary education buildings. And what the committee substitute does at the end of that particular paragraph is it just adds in and says, or enter on a private primary or secondary education building, structure, facility, where such is not allowed by the written policies of the private educational institution. What that, the attempt there and what that intends to do is, I believe, is to allow private schools, if they have written policies, that would permit a person to possess a firearm or other deadly weapon on a school bus, for that to be okay, for them to be able to allow for that to happen if they have their own written policies providing for that. And that was done, I believe the chairman might have mentioned that, at the request of some private schools. They wanted to be able to have the opportunity to do that. So that is why that was added in. And our last section that is affected, and this is the second of the two totally new sections. The new code section is 61-7-15A. This provides for enhanced penalties for any person who uses or displays a firearm during the planning or the commission of a felony. If a person does that, if just a person that is not a felon, what this section says, subsection A says, if a person that does that is not a felon, that person will be sentenced to an additional term of imprisonment in a state correctional facility of 5 years, and that sentence may not be reduced or suspended. Subsection B addresses felons, people that have been previously convicted of a felony. Any felon who uses or displays a firearm during the planning or commission of a felony, in addition to the punishment provided for the felony, these people will now be sentenced to an additional term of imprisonment of 10 years. That 10 years is to run consecutive, not concurrently, with the sentence, and it may not be reduced. So what it says is if you are not a felon, if you are not, then you have an additional 5 years that will be tacked on as an enhanced penalty. If you are a felon and use or display a firearm, you are going to have an additional 10 years tacked on, and that is that sentence cannot be reduced or neither one of those sentences can be reduced or suspended. And Mr. Chairman, I think that addresses all 7 sections.
Thank you, counsel, for that thorough explanation. Before we get into questioning, I just need to mention a couple of things. You probably have noticed you have a handout on your in front of your chair there. We also had, and it was distributed by a member of the committee, just so we can restate what I think I understand the policy to be, if you have materials you want to share with the committee and you're a member of the committee, you simply need to make enough copies to distribute and initial it or sign it so we know it is a committee member. Otherwise, those type of materials have to come through the chair and be approved. And we will try to distribute materials we receive during the public hearing during the floor session. We also were given a number of boxes with petitions in them, but unfortunately there weren't enough boxes for everyone. So I'll have one up here, and there are some additional boxes. These are apparently petitions signed by a lot of people. And if you want to inspect those or pick up a box in the back, but we're not going to distribute them to you personally because there weren't enough to go around. Now, let's take questions of council for about 20 minutes, and then we'll recess for the floor session. Questions of council. Gentleman from 67, Delegate Skinner.
Thank you, Mr. Chairman. Thank you, council, for your explanation. I want to go back to 6172, actually, which is it's not, I don't think it's in the bill.
That's correct, it's not.
It's not in the bill. So none of the definitions of deadly weapon are being changed by this bill. Is that right?
That's correct.
And the deadly weapons, well, let me ask you this. Today, a concealed permit, is that for all deadly weapons or is it just for firearms?
I believe it's for pistols and revolvers.
Okay, so one cannot get a permit to carry nunchucks, switchblades, gravity knives, brass knuckles. Is that fair?
I believe that's fair.
And likewise, and those are all included in the definition of deadly weapon, right?
They are. That's correct.
And likewise, the definition of deadly weapon includes explosives, chemical, biological, and radiological materials. Is that right?
Yes, yes, sir, it does.
If I read the bill correctly, if we go to 6173, it looks to me like any of those deadly weapons that I've just described are now going to be legal for someone over the age of 21 to carry. Is that correct?
Yes.
So someone can create a bomb and carry it, and it will now be legalized in West Virginia.
I believe as it was written, that is, it does state just a concealed weapon.
Okay.
I'm sorry, a concealed deadly weapon. You are correct.
So the knives, the brass knuckles, all of that is going to be permissible under this bill for someone over the age of 21 to conceal and carry.
Right. 6173 deals with people between the ages of 18 and 20. That is correct.
Okay. Thank you, counsel.
Further questions of council? Gentleman from the 62nd, Delegate Overton.
Thank you, Mr. Chairman. To council, I appreciate your explanation. We're dealing throughout this with U.S. citizens or aliens or other residents. Could you describe or explain what other, would that apply to refugees? Would it apply, what would the legal status definition be for the non-citizens?
The legal, as it was included in section 61-7-4, on the date an application is made, you have to be either a U.S. citizen or a legal resident thereof, as well as a resident of the state. I'm not sure about our courts, but I think that other courts, I have found case law in other courts. For example, I believe the Eastern District of North Carolina, and this was for a concealed carry permit statute, they found that a legal resident was someone that held a valid green card and that had been in that particular state for some time. And they found it to be anyone other than an illegal, if again, and I will look at the case again to confirm, but anyone other than an illegal alien, as long as you are not an illegal alien.
is that defined by state or by federal?
I'm not sure that it's defined right here at all. Let me. It is not defined within the definition sections of Article 7 of Chapter 21.
So that could mean a refugee?
If a refugee is considered to be a legal resident of our state.
Thank you, Mr. Chairman.
Gentleman from the 36th, followed by the gentleman from the 35th.
Thank you, Counsel. I'm feeling a little shock here at this moment. Are you saying that because on page 18, because I'm sorry, I'm in the bill. Wait. Make sure I'm in the right place. Shoot. Where were you just discussing the, right before 11A? I've got the one. Yeah. Page 10. No, that's provisional. Where is the section that you were just discussing about about citizens and legal residents in the ComSub?
I'm sorry, it is on page 3 of the ComSub. On the very bottom line, it says that on the date the application is made, the applicant.
Okay, now that's just on the permit, but I'm concerned about the concealed.
Oh, I'm sorry, I misunderstood your question. I believe the original question that we were talking about, that actually dealt with section 61-7-3, which would be page 2 of the ComSub, subsection A.
This is intended to be a question, but it's also a comment. I thought this was a fairly simple bill that basically exempted folks from the permit requirements. That you could carry a concealed weapon if you're over 21 years of age. No training, no any requirements. Just to, But as I'm reading through it, it ends up being a fairly complex matter. And then, as I understood the question from the delegate just before, that we're dealing with deadly weapons. We're allowed to conceal deadly weapons as opposed to firearms. And until that discussion, I thought we were talking about carrying firearms. But you're saying that someone could, literally a suicide bomber, could wear a bomb under their coat and come within the purview of, as long as they're a resident. I mean, they don't even have to be a citizen of the United States. Is that right?
Well,
I'm lost.
Okay, well, okay, with respect to the provisional license, and I'm not sure that I'm going to be right on target, but with respect to the new section dealing with a provisional license for people between the ages of 18 and 20,
Right.
those people do have to be a resident of West Virginia. To obtain a provisional license, you have to be a resident of West Virginia. With respect to what some people are calling the permitless carry or the constitutional carry, that is not limited to West Virginia residents. That is limited. That is not limited to West Virginia residents.
Does it limit it to firearms as opposed to explosives?
The concealed carry permit, as I understand it, generally speaking, is just for pistols, covers pistols and revolvers.
Where is that?
It might take
In
me
the
a little
concept.
time to find that. I'm not sure.
I found it in the green bill, but I couldn't figure it out in the concept. People keep referring to the permit process, but I'm talking about the non-permit process, the concealed carry without a permit. Does it say deadly
The
weapon, or does
concealed
it say
carry
firearm?
without a permit says,
Would it be on page 19,
yes.
line 69? Any person 21 years of age or older may carry a concealed deadly weapon, not firearm, right?
That is what it says. That is correct.
And the section that's not in the bill says deadly weapon includes explosives.
The section, the definition section that is not within the bill does, and I can reference that. The definition section which is not affected is 61, well, not at least in this bill, 61-7-2. It is not part of this bill. That is correct.
So this isn't just about carrying a firearm or, say, a pistol. It's about carrying explosives, at least as it's written now by definition.
I believe that that argument, I mean, I understand the argument that you're making with respect to that.
Well, and would a police officer have reasonable cause to stop someone who looked like they had, dynamite strapped to their body? I mean, would that be something that they could reasonably do if it were legal?
With respect to reasonable suspicion in the criminal law, I am not an expert in that area.
Thank you. Now, the provisional license, a lot of the pages in the bill really relate to the provisional license. That only affects people who are 18, 19, and 20.
Right, until their 21st birthday, only between the ages of 18 until they attain the age of 21. And that is the new section 61-7-4A, I believe.
Now, on page 16, it refers to persons between the ages of 18 and 20. That would be age 19, would it not? I'm technically on page 16, the last line, line 2, section 6. It just says any person between the ages of 18 and 18-20. Wouldn't that be 19? Shouldn't that perhaps be rewritten?
Yes, that's fine. That is the intent.
And do you know where persons are not allowed to carry firearms? The state capitol, I think. Schools, courthouses, courthouses that also house, and that is contained within, some of those are listed in this particular bill, 4145. In addition to courthouses also, and houses that house family law in case the family law courts happen, I guess, not to be in the actual main courthouse, those are also excluded. School buses are also included with respect to the schools. Now, what about private landowners? Are they able to control their premises?
They are. That is a different section. I can find that for you. That is not affected by House Bill 4145, and it does permit people, that is 61-7-14. Again, that is not encompassed in this particular bill, but what it provides for is any owner, lessee, or other person charged with the care and custody of real property may prohibit the carrying openly or concealing of any firearm or deadly weapon on property under his or her domain. And then certainly, I'm just reading the first sentence of it, but there is a section that does address that, but again, not addressed in 4145.
And it already says that a private landowner can prevent a person with a concealed permitted firearm. They can still prevent them from coming on their premises. Say if a restaurant or a bar, are there any special classifications beyond just private property?
No, it doesn't really limit it to private property. It just says as long as you are the owner, lessee, or a person charged with the care, custody, and control of the real property, you have the ability to prohibit having someone carry either in an open manner or in a concealed manner. And then
Even with a permit? concealed, right? If you have a permit, does that overcome the private owner's right to exclude?
No, you do not have the right to do it, even if the owner or the lessee, that class of people, request that you do not. It's actually a crime. It is a misdemeanor. That particular section, Code Section 61-7-14, and let me look at my pocket part to make sure it has not been updated, but it does provide that a person who refuses to temporarily relinquish possession of such firearm or other deadly weapon after being requested to do so, or to leave. If you can also ask that person to leave while in possession of such firearm or other deadly weapon shall be guilty of a misdemeanor, and that is.
And is the posting of a no weapons, you see this around town, of no weapons sticker or something or notice, is that sufficient notice not to carry?
I'm not sure that I ran across that in my research, but again, the section just says that the owner does have the ability to do that.
And with concealed, can the person have a loaded, say a loaded revolver? I mean, the bill will allow not just carrying the weapon, but also carrying it loaded and ready to fire.
I believe so.
Thank you, Mr.
Gentleman from the 35th, Delegate Byrd, followed by the gentleman from the 38th, Vice Chairman Lane.
Thank you, Mr. Chairman. Council, I need some clarification or if you know the reasoning behind the distinction between these two sections. On page 3 of the bill, lines 14 to 15. Let me know when you're there.
I'm there. I'm sorry.
No, you're fine. It says United States citizen or legal resident thereof and resident of this state and of the county. And then when you look over on page 19, it states that the person is a United States citizen or a legal resident thereof, which I believe the legal resident thereof refers back to this state. So is there why is there a distinction? Why is there an and in one section and an or in the other?
I believe with respect to the distinction is the and that you are referencing that's located on page 3 actually deals with those people. The applicant that wants the permit. So if you have if you want a permit in West Virginia, they've added the original, or this bill adds the requirements that you be a U.S. citizen or legal resident, as well as a West Virginia citizen or West Virginia resident. So for an applicant, you have to be both. But with respect to page 19, that deals with for the terminology, either the permitless carry or the constitutional carry, you do not, it is my understanding that you do not have to be a resident of West Virginia.
Okay, so anyone out of state can come in here as long as they're 21. They can carry concealed,
as long as they're not a prohibited person.
And they might not even be a United States citizen. Since there's an or there.
That's right. They may just. That's correct. They may be a legal resident. And as I indicated, there was a case last year in the Eastern District of North Carolina where there was and again, it was a district court case with respect to an injunction, and it was someone applying for a concealed carry permit in North Carolina. That person was a German citizen, and it was a female, as I recall. She was not permitted to apply for the concealed carry permit in North Carolina and filed for injunctive relief, and was granted injunctive relief because she was found to be a legal resident.
Okay, and that's my question. I know that, and you as well as I know, that residency under the case law is like intent, but then there's also residency requirements for DMV, there's residency requirements for voting. So what does this bill deem residency for those two sections?
I don't know that it's specifically addressed other than in that, other than to say legal resident. A U.S. citizen, which certainly can be proven, or a legal resident. In that particular case, I think it was found with respect to, I can't recall. I think she was a green card. I think hers was through a green card, if I recall that case. But with respect to your question, this particular bill, 4145, does not go into detail with respect to that particular requirement. It just has those two additional residency requirements added into the application process.
Okay. Thank you, Mr. Chairman. Thank you, Council.
Gentleman from the 38th, Vice Chairman Lane.
Thank you, Mr. Chairman. Ms. Kaufman, I'd like to go back for just a moment to the questions raised by the delegates from the 67th and the 36th with respect to explosives. As I'm looking at 6172, the definition in sub 9 of deadly weapon, it says the term deadly weapon shall include but not be limited to instruments defined above, which is all the knives, revolvers, blackjacks, those sorts of things. And then it doesn't, it has an all-inclusive, something that may cause bodily harm or death. And then the only place, as I read it, correct me if I'm wrong, the only place that I see explosives mentioned in that definition is in relation to being used for the purposes of Section 1A, Article 5, Chapter 18A, which is a Safe Schools Code, or Section 11A of the article before us. Is that correct?
And I'm sorry, you're talking about the definition, Section 6172, subsection 9, with respect to?
The definition of deadly weapon as discussed earlier by the gentleman from the 67th.
I'm sorry, I'm checking all of the pocket parts to make sure
Sure.
that. That is correct. The word explosive, chemical, biological, and radiological materials does indicate for purposes of Section 1A, Article 5 of Chapter 18A of this code.
And after checking the title of the bill before us, we're not repealing the Safe Schools Act, are we?
Correct. It is not being affected at all.
And so if we read that definition, then in conjunction with the Safe Schools Act, those explosive, chemical, biological, radiological materials are still prohibited in schools.
That, I believe that is correct.
Okay. And so we're not going to be allowing explosives and dirty bombs and that sort of thing on school grounds by passage of this bill.
I believe that that is correct.
Okay. And if we look at the other section which is referred there, which is 11A of this criminal chapter, 61, Article 7, that section is actually contained in the bill, isn't it, on page 19 and 20?
Yes. 11A is addressed in House Bill 4145.
And that is the criminal aspect of the Safe Schools Act. And that would prohibit, again, reinforce the prohibition against carrying any of those deadly weapons on school grounds. Is that right?
That is correct. In addition to, I believe it also talks about school buses in that particular one, as well as the school grounds facilities. That, if I recall correctly, I'm looking, does also, I believe, encompass VOTEC centers, if I recall correctly.
And so we've eliminated any of the school issues with carrying dirty bombs into schools. Let me ask you this question. If currently, to your knowledge, is it illegal for a person to walk down the street with a suicide vest on, an explosive suicide vest?
I would say that it is.
And even the current law for concealed carry, if you get a concealed carry permit, you can't conceal a suicide vest and walk down the street with it, right?
Correct.
And even though that may be considered a deadly weapon, under current law, your previous answer was you believe, to the best of your knowledge, that it is currently illegal to open carry a suicide vest as a deadly weapon. And so would this bill, to your knowledge, as it's before us, change or legalize the carrying of a suicide vest down Main Street.
I do not believe that is the intent of the bill at all.
Okay. Thank you. Thank you, Mr. Chairman.
Ladies and gentlemen, we'll be in recess until 1 hour following the conclusion of the floor session.